Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and welcome back to Ask the Lawyers. Today we want to ask the lawyers about product liability, household product liabilities, and not specifically about, little things that go wrong, products that just stop working for whatever reason, but products that sometimes can have catastrophic effects when there may be a problem with them. There was a story in Texas a couple years back where a clothes dryer, something we all have experience with, an electric clothes dryer, due allegedly to manufacturer defect, caused fire, and unfortunately, tragically, 4 children died as a result of that fire. So today, our expert is Stewart Eisenberg from the Eisenberg Rothweiler Law Firm in Philadelphia. Stewart, thank you so much for joining us today. I appreciate it.
My pleasure, Rob. Thank you.
So let's talk about product liability, household product liability specifically. Give us a little recap. Fill us in. What does that mean, and what's involved in that?
Well, in a products liability lawsuit, that means that someone has used a particular product either around the house or in their car or on the street or in their business or at work, and something goes wrong and causes an injury. And you gave a good example, which was a fire. So there are products around the house that can cause fires. There are products that can cause injury to children. There are products that can cause all sorts of harm and damage when they aren't designed properly. And when that happens and a catastrophe occurs, the people that are involved can bring a lawsuit against the manufacturers or the sellers of that product who weren't designing it with safety in mind.
Where is the line as far as how much is the manufacturer's responsibility? How do you determine whether it's a manufacturing defect, or where is the responsibility on the user and the consumer? I guess that's where your job comes in.
Right, and products liability is a little bit different than a normal lawsuit because in a normal car accident or things like that, we talk about negligence and who's at fault and whether you were responsible or the other party was responsible. In products liability, the focus is on the safety of the product, and the jury ultimately determines, is that product safe or is it not safe? The fact that someone uses it in one way or another way or may be negligent does not come into play at all unless the consumer or the person who was hurt assumes a risk. And that's a very high burden that the manufacturer would have to say, okay, this person that was using the product, this person that was in a car seat, this person that was using a smoke alarm, this person that was using something that we made, knew what the risk was, and therefore we're not responsible because they knew what it was and they went ahead and used the product anyway. A good example of that is something like a firearm, a gun or a knife or something like that, where somebody knows there's a danger and goes ahead and uses that product. Then if they get injured, the manufacturer can usually win that case.
But if it's a clothes dryer, there's no inherent, they shouldn't realize that there's a risk involved with using a clothes dryer.
Right, that's a normal household product that everybody uses very frequently, and there is no assumption of the risk there unless you jump inside of it and hurt yourself while you're tumbling around or something like that.
It seems like every product we buy these days, especially if it has a plug and goes into the wall, has got stickers and tags and warnings all over them. Is that enough? Does that keep the manufacturers from having any sort of responsibility?
No, there's a doctrine called failure to warn. And if the warning is clear and obvious and covers all the factors and all the possible outcomes that could occur if something bad happens, then a manufacturer has fulfilled their duty to warn. But then that's just one aspect of products liability. There's the manufacturing defect. Did they manufacture this product properly? And did they design the product properly with all the safety features that they knew or should have known? Were they taken into account, and are they part of that product?
Do you have any examples for specific cases maybe that you're familiar with, that your firm has handled, that fall under these categories?
Well, the one that is most relevant, I think, particularly at this time of the year, would be products that children use and are given as gifts or use on a regular basis. The one that comes to mind right now is the child car seat.
Oh, yeah.
That is the car seat that's put into your car, whether it's for an infant coming home from the hospital, or whether it's a child who is 3 or 4 years old, or whether it's almost a teenage child, 8 or 9 or 10 years old. There are different kinds of car seats, and if there's something wrong with that car seat and does not protect the child in the accident that occurs, an accident that perhaps occurs and jostles the child around, or causes some sort of injury to the child that shouldn't have happened, that is a products liability lawsuit. We've had a case on a number of occasions where children have been injured in products, child car seats, where the harness was not designed properly, and the child's head can move forward, hit the back of the front seat. The child can move up and out of the car seat and be thrown around in the car, and that's something that should not happen. A properly designed car seat should protect children in accidents and protect them from getting injured or killed.
And speaking of car seats, it seems like a lot of times the discussion is, well, the seat wasn't installed properly, but is there a point where you go, that seat is too difficult to install properly to that standard, and that can be an issue too?
Well, generally, that is a defense that somehow the product was not installed properly, but that's not a defense in a products liability lawsuit. There's a doctrine called misuse, and that means using a product for something that it wasn't intended to be used for. I may be showing my age, but back in the Ronald Reagan era of the 80s, he used an example of a lawnmower being used to trim hedges, so that somebody put a lawnmower up on a tree, and somehow the person got hurt. First of all, that story wasn't true, but secondly, that's something that you don't do. You don't use a lawnmower to trim your hedges. You use a hedge trimmer.
Right.
So you don't use a screwdriver to screw in a light bulb. Those things are what's called misuse. But in the car seat example, the mother or the father or the relative who's putting in the car seat is using it for the purpose that it was intended to be used as a car seat. If for some reason it wasn't installed exactly the way the manufacturer intended, that's foreseeable by the manufacturer. They know that car seats are difficult to install, and the instructions need to be very, very particular. But generally, we find that car seats are installed properly, and the way the manufacturer intended it to be installed. And if it's unsafe, and if it's not designed properly, and a child is injured or killed, we can prove that the manufacturer did something wrong.
Let's stay on the topic of children at this time of year, children, gifts, toys, that sort of thing. Do we still see cases? It seems like a few years back there was always children's recalls of toys and that sort of thing. Is that still an issue? Products that are dangerous for children, or have we fixed that?
Absolutely, there are products that still are dangerous. We've handled cases where children have been choking and asphyxiating from magnets that are in products, from batteries that can close off an airway, from all sorts of small little items, marbles and things of that nature are certainly not to be used by small children. But even the small children's products are oftentimes not safe. Now, the manufacturers have gotten better at making toys that are appropriate for particular ages, and they put the age-related warning on the package. But there are cases involving children's pajamas, for instance, where they can catch on fire if they're not made with fire retardant materials. There are cases involving furniture around the home, particularly dressers made by IKEA, that have fallen on children. Those aren't gifts, but those are risks that generally parents don't know about.
Right.
And who would think that a child would get crushed by a dresser that was unstable? So there are many things around the home that parents are aware of and protect their children, but there are also many things that are unknown. And if that happens and a child is hurt or killed, there may be a claim for products liability.
You mentioned package warnings. Children's products, they all seem to have suitable for ages whatever to whatever. Is that enough to absolve the manufacturer of any sort of responsibility should there be some sort of injury?
No, absolutely not. If a child's using a product, for instance, that's good for ages 1 to 2, and there's a magnet or some sort of material in there that could easily be swallowed or could easily cut someone and cause serious injury, the manufacturer is responsible for that. If they could have and should have designed the product without that magnet, without that sharp edge, without that defect, then they are responsible, regardless of what they put on the package. They're not designing the product safely, and that's the key. Safety is the ultimate responsibility of manufacturers, of companies that make these products for children.
What if somebody buys a toy for a child that's used, or buys a product that's used? Where does that fall in as far as responsibility? Maybe it doesn't come with all the pamphlets and the paperwork and all that sort of thing. Does that change the way this all plays out?
No, it doesn't change it at all. It's similar to if someone buys a used car. There's no limitation on bringing a claim against Ford or GM or Chrysler for a year-old car or a 10-year-old car. If it was designed improperly, it was designed improperly. And in fact, one of the cases we handled involving a child car seat was a car seat that was bought at a house auction sale.
Oh.
That was sitting around in someone's home. They weren't using it anymore, and they sold it at a lawn sale or a garage sale. Those things, so long as you can identify who made this product, they are responsible for what is normal and everyday use. If for some reason the product didn't have everything that it was supposed to have because it was so old and things wore off and not everything was there, then perhaps there's an issue. But generally, just because it's used, just because it's old, doesn't mean there isn't responsibility.
It seems to me that these days, many times you're not buying your product, you're not face to face with the person you're buying it from. With the internet, with Amazon, you may not ever realize who actually the manufacturer is. If it then becomes a situation for product liability, does that make your job more difficult, trying to track down who the manufacturer is, and they may be in China or who knows where? How does that affect all of this?
Well, that's a good question, because there are some issues, but one of the main takeaways from today, if there could be one main takeaway, is if you are injured by a product, or if your child is injured by a product of whatever nature, keep the product. Don't get rid of it. Don't get rid of the glass if something explodes, an exploding bottle. Keep the glass. Keep the car seat, because a lawyer who is experienced in this area can determine who the manufacturer is. and we can track down almost anything and everything. So if it is a manufacturer in China who doesn't do any business here in the United States, that could be a problem. But then we look to who sold the product and who put it on the market, because a seller is just as responsible for the safety of their product as a manufacturer is. Now, generally, we know who the manufacturer is, so we don't always bring a case against the seller, because the seller has sort of a secondary responsibility. They didn't design the product, they didn't manufacture the product, but they sold the product. And under the doctrine of products liability, in most states, a seller is just as responsible as a manufacturer, a distributor, a wholesaler, the whole chain of commerce, we call it, from beginning to the time of the sale. Any intermediary can be held responsible.
Oh, that's really good information. Very helpful information. Stewart, thank you so much for your time today. I really appreciate it.
Thank you, Rob. It's my pleasure.
I think we've hopefully helped a lot of people today. My name is Rob Rosenthal with AskTheLawyers.com, and that's another edition of Ask the Lawyers. We hope you'll go to AskTheLawyers.com, where you can choose a lawyer that lawyers choose. Have a great day.